أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يسبح لله ما في السماوات وما في الأرض الملك القدوس العزيز الحكيم. هو الذي بعث في الأميين رسولا منهم يتلو عليهم آياته ويزكيهم ويعلمهم الكتاب والحكمة وإن كانوا من قبل لفي ضلال مبين وآخرين منهم لما يلحقوا بهم وهو العزيز الحكيم. ذلك فضل الله يؤتيه من يشاء والله ذو الفضل العظيم. مثل الذين حملوا التوراة ثم لم يحملوها كمثل الحمار يحمل أسفارا بئس مثل القوم الذين كذبوا بآيات الله والله لا يهدي القوم الظالمين. قل يا أيها الذين هادوا إن زعمتم أنكم أولياء لله من دون الناس فتمنوا الموت إن كنتم صادقين ولا يتمنونه أبدا بما قدمت أيديهم والله عليم بالظالمين. قل إن الموت الذي تفرون منه فإنه ملاقيكم ثم تردون إلى عالم الغيب والشهادة فينبئكم بما كنتم تعملون. يا أيها الذين آمنوا إذا نودي للصلاة من يوم الجمعة فاسعوا إلى ذكر الله وذروا البيع ذلكم خير لكم إن كنتم تعلمون. فإذا قضيت الصلاة فانتشروا في الأرض وابتغوا من فضل الله واذكروا الله كثيرا لعلكم تفلحون. وإذا رأوا تجارة أو لهوا انفضوا إليها وتركوك قائما. قل ما عند الله خير من اللهو ومن التجارة والله خير الرازقين. صدق الله العلي العظيم.
Thank you, Brother Azim. My name is Abbas Panju, and I will be your moderator for this evening. Just a few housekeeping items before we get into the program. First of all, as you were registering at the tables to my left and right, you may also have noticed that we are the bookstore is selling the book, Writing an Islamic Will, for $5. So for those interested, please do purchase this book for $5. A brief overview of the program. Following the short introduction, we will begin with two talks, one by Brother Samil Chagpar and the next by Syed Maulana Muhammad Rizvi. This will then be followed by a question and answer session. Over the course of the lectures or of the talks, if you do have any questions, please feel free to either remember them or note them down on the pads provided, again at each of the tables. So for those who are uncomfortable coming up to the mic to ask a question, you can submit it on a piece of paper. We encourage all of you to please listen attentively in order to avoid having repeated questions that are repeated in the question and answer session, so that we can give an opportunity to have as many questions answered as possible. For those of you who have very specific questions, we would encourage you to see either Samil or Syed Maulana Rizvi after the program so that they can give you a more personalized answer. So now, without any further ado, I am pleased to introduce Brother Samil Chagpar. Born and raised in this community, Samil has been practicing law over the past 3 years. And contrary to his outfit, he didn't get lost on the way from the courtroom. He currently works at a full-service law firm in the Richmond Hill area, SBMB Law, specializing in family and civil law. And Samil, knowing him personally, he's one of the nicest guys you'll ever meet and always looks for opportunities to give back to the community. You might recognize him as one of the leaders of our 392 Muslim Scouts troop. And he's thrilled to be here today. So please join me in welcoming with a loud salawat, Brother Samil Chagpar. Allah.
Maulana Rizvi, brothers and sisters, Assalamu alaikum. Thank you all for your attendance here today. The topic is, I'm sure, of great interest to the community, especially given the large turnout that we have here. Let's start by looking at the issue of a will and what the will itself is. The will is a legal document that permits a person called the testator to make decisions on how his or her estate will be managed upon their death. Very simple. It's a document that sets out a person's wishes and intentions. 3 very common intentions of why people want to have a will are then, first, to express your intentions on how to divide your estate. Second, to protect against disputes between potential beneficiaries. If everything is clear and set out in writing in advance in a clear document, then hopefully those who stand to gain at the end will be less likely to fight over it. And thirdly, to minimize tax consequences. Everyone's always looking to save some money, and of course, doing a will properly can also help you to incorporate some of those intentions as well. Now, generally, in order to make a will, you must be at least 18 years of age. I say generally, there are some exceptions, but you must be 18 years of age. The will must be in writing, signed at the end of the document, dated, and witnessed by 2 people who are not going to be beneficiaries in the will. In addition, the witnesses can not only not be beneficiaries, but they also should not be spouses of beneficiaries. The purpose of this requirement is to avoid any impropriety. We don't want a will to have a suggestion that perhaps one of the witnesses was unduly influencing or coercing the person who left their last wishes. So those are very important requirements. Now, when I said generally those are the main requirements, it is also possible for a person under the age of 18 to make a will, provided that they are married. Or the other exception is if you're part of the armed forces. So those are 2 other exceptions that may not apply to most of the community, but generally over the age of 18, in writing, 2 independent witnesses who are not beneficiaries or spouses of the beneficiaries. Those are the takeaway messages. Now, of course, if you're using the services of a law firm, it's a fairly straightforward procedure. It doesn't take very long at all. You would have an initial consultation with your wills lawyer. They would go through your assets and liabilities and such with you, put together a will in accordance with your intentions. If you have some specific requirements, for example, you want to leave things in a certain way based on Islamic guidelines, etc., the lawyer can incorporate all of that and then meet with you again to sign it. So it's a very easy process. It's not overly complex or difficult, and it can usually be taken care of within a couple of days. Now let's look at what forms part of your estate. Your estate is everything that's left over when you die. In the law, there is a deemed disposition that you have sold all of your assets upon the date of death. In simpler language, what that means is when you die, everything that belongs to you, real property, personal property, etc., is taken to have been sold as of that date. You're liquefying, you're putting in monetary value on all of your assets. That's what that means. So deemed disposition, that you, as if you would have sold all of your assets the moment before you die. So that's what forms your estate. I said property, including real property, which is residences, condos, and such. Personal items includes investments, RRSPs, etc. All of that will be part of your estate. Now, there are certain exceptions to this. There are some things that are part of your property that do not make up your estate. And this is important to know, especially if you're thinking about how to minimize tax consequences, for example. If you have property that is held jointly, for example, a joint banking account, or maybe your residence is held jointly with your spouse, any joint property does not form part of your estate. In fact, what happens to it happens outside of the regular laws of dealing with your estate administration. The reason for that is the law in Ontario and Canada says that joint property will automatically flow to the other joint partner. That's the point of having a joint. If you have a bank account joint with your wife, for example, and you were to pass away, it doesn't need to be included in your list of assets for your estate. It would automatically be, transferred to your wife. She would automatically become the 100% owner. The same thing goes with a residence. If you own your home, a matrimonial home, or your primary residence, to keep it simpler in terms of language, your primary residence is held jointly. There's an automatic transfer that can be done. You have to fill out a form. It's called a survivorship application. There's, of course, a little bit of a fee you'd have to pay to a lawyer, but simply the property can then transfer over to the person who it's held jointly with. And again, that's important if you're intending to try to minimize some of the tax consequences. While we're talking about primary residences, I just want to also elaborate. There are two ways that you can hold property. One is joint tenants. That's what we've just been talking about, the automatic transfer to your partner. The other way is called tenants in common. So some of you may be familiar with this. Perhaps when you've purchased property, your lawyer may have asked you the question, well, how would you like to hold the property? Do you want to hold it as joint tenants or tenants in common? And most people will say, well, I don't really know what the difference is. So, do whatever is more favorable. The difference is this. If you're tenants in common, that means you would own your half of a property and your partner would own their half of the property. If you were to pass away, your 50% doesn't get automatically transferred to your partner, unlike the joint situation. In the tenants in common situation, your 50% becomes part of your estate and everything that goes with that, including the tax consequences, and not just negative, but also on the positive. At least you have a better way of disposing of that 1/2 interest. As we'll hear later on with some of the Islamic requirements, this is perhaps a good way to be able to divide your property so that it doesn't automatically get transferred over to the joint partner. Perhaps there's a reason you want it to be part of the estate. So that's just an important thing I thought I would point out, because not a lot of people are aware of that distinction between joint tenants and tenants in common. But we all are in the business of purchasing homes and selling homes, etc. So it does come up a lot. The other exception of property that flows outside of the estate is property that has a specific designated beneficiary. So for example, life insurance policies. On the whole, that it's not an asset that would be considered as part of your estate inventory that you would keep. There's a specific designated beneficiary who is going to be the intended recipient of a life insurance policy. Upon your death, that policy flows outside of the estate for tax purposes and such. It will go directly to that intended beneficiary, tax-free. In addition to life insurance policies, there are also RRSPs. Oftentimes there are other investments where you can actually designate a beneficiary for that. So for example, if I had RRSPs and the designation of the beneficiary was my wife and I were to pass away before I even realized on the RRSPs, let's say I wasn't eligible for them or I hadn't cashed them out, it would flow outside of the estate. It would go directly to the name of the person who's the beneficiary. At the end of the day, someone will have to pay tax on that RRSP when it's ultimately cashed out. Maybe your estate's not paying it today on the date of your death, but at least you're putting off the tax consequence to a little bit later, perhaps at a time where it's more favorable for your partner to withdraw that tax or to withdraw the RRSPs. Perhaps they don't have a regular income at that point, so it'll be less of a tax consequence. So those are important things to note. In terms of trying to minimize your tax liability and tax consequences, some of these assets, investments, RRSPs, if you designate a beneficiary to them, they don't form part of the residue or the balance of your estate. Now, a lot of times people ask the question, well, once I've invested in making the will, I've gone through the process, I've put my mind to what needs to be done, I've perhaps consulted with spiritual and legal advisors on how to do it properly, can I make changes to this will? How difficult is that to do? It's actually not very difficult. If you have your will drafted and you want to make some changes to that, it's like you're making an amendment or an appendix to that will. It's called a codicil. It's a specific name that's given to legal documents that are going to be attached to a will. It's not replacing the will. It's an addendum. It's an attachment to it that can be made later on during your life as certain things change. Perhaps you had contemplated one specific asset going to one individual, and now you want to do a codicil to make a small change. Maybe you don't own that property anymore. So it's fairly easy to make changes to your will and do it in the proper manner. On that note, if there are ever any major changes in your life, major changes, I say, would include things like marriage, divorce, new children coming to the relationship, and so on, any major changes should automatically make you think, we need to re-examine the will because there could be some drastic changes that you may not have contemplated. Can you imagine if you had drafted a will with everything going to your partner, your spouse, for example, and, God forbid, that relationship broke up? What would happen? Would everything go to your former spouse? Maybe that wasn't the intention that it once was. So it's important to always re-examine this as there are different major changes throughout your life. Now, on that note, since I mentioned that specific example, your will is automatically considered revoked upon marriage. So if you had one will now, and then you were later to get married, your will in law is automatically considered revoked unless your spouse chooses or elects to take, as per that will. So it's possible that the one will you may have done early in life, perhaps as an unmarried person, could continue. I would suggest that you do re-examine it, but it's possible that it could, continue in the form that it was if your partner chooses to elect. But really, you should be re-examining your will every time there's a major change in your life. Now let's talk about one of the most important things that I think everyone needs to know about, and this is what happens if I don't write a will? What does the law say? Do I lose everything? Does it go to the government? Some people are worried that, there's this fear, I don't know what's going to happen. Well, I agree, you should be worried that, you don't know what's going to happen, that things might happen outside of your control, but it's easily correctable. Simplest way, write a will. Plan in advance and look after that. So let's look at what happens when you don't write a will. There is a piece of legislation out there, law, called the Succession Law Reform Act. Succession Law Reform Act. This is the law in Ontario. Every province is different, but they have similar legislation that sets out the rules of how a person's estate is to be divided if they die with a will, without a will, if there's a joint survivorship situation, etc. So there's different considerations like that. Of particular importance to those who don't have a will, Sections 44 to 49 of this Act, I don't need to set out or read out the sections verbatim, but in summary, what they say is that if you have a spouse and you're dying without a will being written, your spouse will inherit everything from your estate. When I say everything, I mean the balance of your estate, after debts and so on have been paid off. So the first thing, when somebody dies and you look at the inventory, here are the assets, here are the debts, this mortgage has to be paid off, this loan has to be paid off. The net of all of that, once the debts have been paid off, everything else is considered the balance, the residue. So the law says that your spouse will automatically inherit all of that. That may be good, that may be bad. Depends on which side of the relationship you're sitting on, I suppose. But that might not be your intention. Your intention probably is you wanted different people to benefit from your estate. Your children, your parents, your spouse, of course. But that's the starting point. If you have a spouse and you also have children, so that first step that I said, it was assuming you just had a spouse. No children in this picture. Spouse would inherit everything. If you have a spouse and you have one child, for example, the spouse will inherit the first $200,000 of your estate. This is called the preferential share. The first $200,000 of your estate, the net of your estate, right, after debts and so on have been taken care of, anything above the $200,000 will then be split equally, 1/2 and 1/2, between your spouse again and that one child. So the spouse in this scenario guaranteed the first $200,000. If you had, let's say, another $100,000 as part of your estate, half of that goes to the spouse again, half of that then goes to the one child. Similar sort of formula if you have more than one child. In the case where you have 2 or more children, so this is the catch-all, if you have a spouse and 2 or more children, spouse will still get the first $200,000 of your estate. The balance, everything over and above the $200,000, the spouse will get 1/3 of that. Doesn't matter how many children you have. You could have 10 children. It won't be 1/10. The spouse will get 1/3 of that, and then the remaining 2/3 will be divided equally amongst your children. 2, 3, 4, 10, however many you have. So those are important considerations to recognize, that that's what the law will do to your estate, whether you like it or you don't like it, if you don't have a will in place. And the consequences, as we'll hear later on from Maulana Rizvi, can be drastic, especially if that's not what your intention was. Now, talking a little bit more about this, it doesn't come up in a lot of scenarios, but, well, what happens if I don't have a spouse and I die without a will, right? If you can't find those different people who stand to inherit. The law also has set out a long kind of list of different people who will then be considered the next of kin. So in a case, if you die without a will and you don't have a spouse, you look for the children. If you don't have children, then the next chain of command, or the chain of inheritance, I should say, would be your parents, and then your siblings, and then your nieces and nephews, etc. So the law has recognized all of this, and only as a very extreme, very last resort that really doesn't happen. It's happened, I think, maybe once in 50 years for one of the partners practicing in our firm. Only in a rare situation would the government seize your asset or seize your estate or take over your estate. That really doesn't happen because, usually there is somebody from this long chain of people who stand to inherit that would come forward to say, well, I'm a nephew of the deceased, and, the parents have passed away, there's no spouse, no children, I think I'm the next one in line. What would I have to do? I would have to bring an application to the court and assert my right to say, well, based on the law, I am the next in line, and here's a sworn affidavit to that effect, and here's some proof that I can furnish. Therefore, court, grant me the legal document that gives me the ability to inherit from the estate. But up until that point, up until somebody takes that active step to contact the court and say, I think I'm the next one to inherit, or I'm the one who stands to benefit, the court won't do anything. They're not proactive. The banks won't do anything with the money. They're not proactive. They're not going to go and look and start advertising in the newspapers, is there a relative of such and such? They don't do that. That's not what they're paid to do. What practically what happens is the money would just sit there for years on end sometimes, tied up in some reserve fund in the bank or something like that. If it gets paid into court, it'll just sit in court for years, earning very nominal interest, maybe, I don't know. But somebody has to come forward and make that claim. So given all of that headache, why would you leave your estate and all of the wealth and so on that you've accumulated during your life, and why would you leave it to chance? It's not chance, but you know what I'm saying. Why would you leave it to that sort of lengthy, complicated, unduly costly procedure? Very simple to work around that. You write a will, you plan in advance, and you put it down in writing. Now let's look at some of the practical aspects of when you pass away. When you pass away, your estate gets managed by an estate trustee. There's another word for this. The words have been changing over the last number of years. It used to be called an executor or an executrix. Nowadays, we call it an estate trustee. It's the same thing, okay? This is somebody who you have specifically appointed and chosen in your will to say, upon my death, I would like such and such person to be the estate trustee, the person who will administer my estate, take care of the liabilities, making sure that they're paid off, making sure that the correct people inherit the way that my will has outlined them to do. So that's somebody that you would choose in your will. And to protect yourself, you usually choose a couple of different individuals. My first choice would be so-and-so to be my estate trustee, and in the event that person was no longer alive or predeceases me, then here's my second choice. You could even choose people to be joint estate trustees. I'd like these two people together to be the estate trustee to help share that burden, help share that load. So that's practically what happens. An estate trustee is then responsible for making sure that your estate is administered, making sure that the final tax return is paid for the deceased, making sure that you get the necessary court documents to probate the will or get the will approved in the court system, things like that. Now, unlike what I said in the beginning of my talk, where I said the witnesses of the will cannot be the beneficiaries or the spouses of the beneficiaries, that's not the case with an estate trustee. It's okay for an estate trustee to also be a beneficiary. There's nothing wrong with that. And in fact, that's quite common. Oftentimes a person will say, this particular child of mine is, very trustworthy. I trust that they're going to administer everything in accordance with my wishes and they're not going to fight with their siblings. I'd also like this son, for example, of mine who's a beneficiary also to be the estate trustee. No problem whatsoever. That being said, it's also okay to have other people who are not beneficiaries, trusted friends, relatives who perhaps aren't going to be beneficiaries, or oftentimes even your lawyer can be an estate trustee. And we see that quite often when people come to get a will done at our office. They also ask our firm to be an estate trustee so that they know that everything will be taken care of in the timely manner and that the lawyer would know what they're doing. Oftentimes an estate trustee has never done this before. How many of us have ever had to be an estate trustee? Probably a very small percentage of those in the room today. So how do you know what to do if you are appointed an estate trustee? Well, you can call a lawyer and they'll offer you services to help walk you through the process. This is what you need to do. You need to do this, and maybe we can help draft some forms if you need help with that. But like anything else, you can get advice on how to be able to do the job that's been appointed to you. The only important key requirement for the estate trustee is that the estate trustee be over the age of 18. That's the only minimum requirement. Otherwise, there's no residency requirements. The estate trustee doesn't have to be living, in Ontario, for example, if that's where you're living. There's no problem whatsoever with that as long as they're over the age of 18. In terms of compensation, the law in Ontario entitles somebody who's appointed an estate trustee to be compensated for their services. It's set out in the law and the legislation that I mentioned. It's a sliding scale. It depends on the amount of the estate and how much we're talking about. A $200,000 estate, you'd be entitled to pay, to receive some compensation for dispersing that. That would be different than, let's say, a $500,000 estate or a $1 million estate. So it's a sliding scale. It's a formula. It's nothing that, I need to give you the different numbers, but generally, it's up to 4.5%. So depending on how complicated the estate is and how big it is, there is some room for compensation, and that compensation to the estate trustee will come from the estate. It's one of the debts or the liabilities that gets taken care of. That mortgage, that line of credit, that personal loan, we've got to pay the taxes to the government. We also have to compensate our estate trustee. Everything that's left, well, that's the balance. That's what's going to then flow to the beneficiaries. Now, while we're talking about the estate, there is a requirement in the law that says you are not allowed to dispose of the estate or finalize the estate for the first 6 months after a person's death. There's a reason for this, and I'll touch upon it a little bit later, but essentially, the law later on, as I'll tell you, allows a spouse to make an election. They can choose whether or not to inherit under the will, or, as I'll comment on a bit later, they can choose to elect under the family legislation. So I'll go into a bit more detail, but for your purposes here, you need to know that there's a 6-month waiting period, as it were, during which you're not allowed to dispose of the estate unless, of course, you have consent from the spouse, because that's part and parcel of the reason why there's this waiting period. But if the spouse consents, then it's okay to just, to take care and wrap up the estate during those first 6 months. Now let's talk about money. Let's talk about taxes. This is something that everyone's always concerned about. Well, I don't want to have to pay the government some more money. They've taken enough from me in my lifetime, my income tax and all this. There is a tax on death. It's not a tax that the beneficiaries would have to pay. So there's no inheritance tax. If I'm standing to receive an inheritance from my parents, for example, I don't have to pay a tax on that inheritance. When it comes to me, it's tax-free. But the tax has to be paid before it comes to me. That's the estate. It's called a probate fee, or nowadays we call it an estate administration tax. It's the same thing. Words have changed a little bit, but for all intents and purposes, it's a tax that the estate will have to pay on the balance of their assets. So when somebody dies, you would take an inventory, a list, an accounting of all the assets and the debts. When you go to court to get your initial court document stamped and sealed, it's called a certificate of an appointment of a trustee. It's a long word, but anyways, it's a certificate that you need to get stamped by the court to essentially approve your will before it gets dispersed. At that time, the estate trustee has to make sure that the estate administration tax, this probate fee, gets paid to the government. How much is it? Again, it's very easy to calculate. It's set out in the legislation, so the amounts are slightly different. In case you're interested, I can tell you the first $1,000 of your estate, there's no tax payable on that. So if your estate is very small, perhaps the estate is in the negative, there's no estate tax payable on the first $1,000 of your assets, if that's all it is. If your estate net assets is more than $1,000, up to $50,000, the amount of the tax, again, it's a formula, it's 0.5%, 0.5%, 0.005, right, of the estate value. So for example, $5 out of every $1,000. That would be the amount. So it doesn't sound like a lot. It really isn't a lot. Once you start adding up larger estates, $1 million, $2 million estates, certainly the numbers can add up a bit more. The tax on anything over $50,000 is 1.5%, or $15 for every $1,000. So practically, to understand it, if you had a $1 million estate, 1.5%, you're paying $15,000 of tax, just to get an idea of how that part of it flows. In addition to this estate tax, there is also a final tax return that the estate has to file with the Canada Revenue Agencies. Just think of your regular income taxes that you file every year. You're filing it for many years because you're working every year. Well, the last year in which you were alive, when you pass away, there's a final return, a final tax return that gets filed. And again, that takes into account whatever income, et cetera, your tax obligations that may have accrued to the date that you passed away. So those are the two key tax scenarios that you would really need to know about: the final tax return and the estate tax being paid on the assets of the estate. Now, a question sometimes has come up, do I need different wills if I have property in different areas? It's a very good question. Think about it. Especially in our community, it's very common that perhaps I'll own some property in Ontario and maybe have that nice sunny condo in Florida. It happens. Or property in different jurisdictions, maybe in the UK and the Middle East. Practically, you only need one will to be able to dispose of your estates. But that being said, it's much, much easier, the different legal things you need to do to dispose of those properties in foreign jurisdictions. It's much easier to have different wills for different jurisdictions. So if you have a condo in Florida, have a Florida attorney or a lawyer there, draft a simple will just dealing with the assets in that jurisdiction, just dealing with that condo in Florida. Have a separate will for all of Canada, a separate will if you have property in the UK. And I say this is much easier for you because if you have separate wills in each of these areas, when you then do the next stage, which is trying to dispose or sell of those assets, you have to do something called resealing. It's essentially it's getting your will probated or approved in that foreign jurisdiction. So to then take your Ontario drafted will and probate it or reseal it in Florida, it's just a bureaucratic nightmare. It can be done, it's just more costly, and there's extra delays that you don't need. Whereas if you thought about this in advance, have a separate will just dealing with that Florida condo, much easier to get it probated down in Florida. Have a separate will for your Canadian assets. You don't need to distinguish between Ontario, British Columbia. If they're in Canada, the will here, wherever it's drafted, will be able to take care of that. Now, the place where the will is approved or probated or receiving that court stamp, it's going to be the place where the deceased primarily resides upon his or her death. So if you primarily reside in Ontario, maybe in York Region, then York Region is the courthouse that you would go to, or Ontario is one of the courts that you would use to be able to probate the will or pay, take care of all those legal things, paying the estate tax and getting the approval so that you can then sell and disperse the assets. So the key is that wherever the deceased resides at the time of his or her death is where the main will is going to be probated. Now just a couple last points before I sit down and leave it to the question and answer. There are some examples of common estate litigation that happens. Our firm deals with, we don't only do wills, but we also deal with the fallout after people die and people are fighting beneficiaries. That's called estate litigation, and it can get very nasty and very complicated and very expensive. And guess where all that money comes out of? It comes out of the estate, paying for all the different lawyers that are involved, sometimes 5 different law firms, all fighting about the interpretation of a will, or maybe this will was drafted in such a way and somebody was a witness where they shouldn't have been a witness, and all these sorts of arguments come up. You don't want any of that. So it's very important to make sure you get the proper advice from the beginning with legal advisors to ensure as best as possible that you're going to avoid any fighting over your will afterwards. Now, one common example that it's difficult to prevent against, but there are ways to deal with it, is, I commented before, dealing with your spouse. And I spoke about this 6-month waiting period, so I'm going to elaborate on that now. Under the law, under a different law, an Ontario law, called the Family Law Act, this is the family legislation that governs our marriages and so on. Under that legislation, a wife or a husband, a spouse, has the right to choose how they're going to inherit. And when I say choose, I mean they can choose to inherit under the will that's been drafted, or if there's no will, then what I spoke about before, the first 200,000, etc., what's in the legislation. So the spouse can choose either to elect under the will, or the spouse can choose to elect under the Family Law Act. Now, what does that mean? The Family Law Act is the legislation that deals with marriage breakups. When parties separate, divorce or whatever, when they separate, there is an important financial irregularity that needs to be addressed. That's called equalization of net family property. In simpler words, it's a splitting, a 50-50 as it were. You're all familiar with that idea from the movies and television that the parties upon a breakup, they split the 50% of the equity in the relationship, right? The assets and debts being taken into account. So the key is that a spouse under the Family Law Act has an overriding ability to elect an equalization payment, 50-50 split, or they can elect under the will. How do you make that decision? Well, people make that decision for many different reasons. Sometimes it's just monetary. If a will says I'm going to get 35%, but the Family Law Act says I can get a 50-50 equalization, maybe that's one reason people will choose to elect under the Family Law Act rather than taking what's under the will. So this is an important potential problem to be aware of. I mean, it's not a problem. It's obviously part of our law and legislation because, it's come from somewhere. The policymakers have felt that in Ontario and in Canada that we need to have those certain safeguards and protections in place. But you should be aware that however you're going to devise your estate in your will, you need to recognize that there is this potential for your will to be challenged by no less than your spouse, by your husband or wife, if they choose to elect under the Family Law Act. Now again, there are ways around it, there are ways to deal with this. And one of the simplest ways to do that, and I know this because I also practice family law, the breakup of marriages, is to do a marriage contract, a domestic agreement, it's called. They used to call it a prenup many years ago. It's called the domestic contract now, or a marriage contract. Very simply, this is something that can be done during the marriage, before the marriage, etc., where you can contractually agree that one spouse will not make a claim against the other spouse's estate in the event of death, and maybe in consideration of that, you do some other things. Maybe you'll say, the reason I want to have that release against the estate is because I want to comply with my Islamic requirements, etc. So there's practical reasons why you'd want to do that. But the point is that there are ways to be able to protect against the scenario of a spouse electing upon your death and potentially disrupting what your intentions may have been, as we'll hear from Maulana Rizvi later on, with trying to comply with the Islamic requirements. Another example of potential estate litigation could be your children making a dependence claim against your estate. So the law also recognizes that minor children under the age of 18 can bring a claim against their parents' estate if they haven't been adequately provided for. What does that mean? Well, it's very case by case, it's specific to each case, but essentially you need to think about that and make sure that you are leaving enough, whatever that means, enough sufficient funds to take care of your minor children. Otherwise, they could bring a claim against your estate and potentially disrupt what your intentions were in terms of the division of your assets. Some final considerations, I'm not going to talk in detail about this, but only to bring it to your awareness that when you're drafting a will, oftentimes you'll go to a lawyer. There are a couple of other important legal documents that you should be aware of that exist out there. And oftentimes as lawyers, we recommend to our clients that you should also prepare these documents as well. Those are the powers of attorney. There are two: powers of attorney for property, to deal with your property affairs in case you're not able to deal with them, for example, mental incapacity or something like that. And the other one is power of attorney for personal care, to deal with treatment decisions and dealing with doctors, etc. So these are two important documents that you should be aware of, and we can explore them in another venue or afterwards. But we oftentimes recommend to people that we suggest that you also have these two documents drafted as well. It's not difficult, it doesn't take a long time, it's not expensive, but it's an important safeguard to also think about, especially when you're drafting a will. So in summary, as Muslims, we're always taught to think about death and to deal with it head on, not to hide it underneath the rug, to be thinking about it. And the best way that we can do that is to think about how you want to wrap up your financial affairs and execute a will so that it's clear to your intended beneficiaries what your intentions are and to minimize that disruption. Thank you very much for your attention, and I look forward to some interesting questions during the question and answer period. Wassalamu alaikum.
Could we please have a loud salawat for Brother Samil Chagpar? Allahumma salli ala Muhammad. Before we move on to our next speaker, could I please ask the gents to please move in closer to this side? People are still streaming in, and so we want to minimize the disruption. So if I could please ask everybody close to the door to please move inwards to my right, that would be greatly appreciated. Thank you. Our next speaker needs no introduction. So without any further ado, speaking on the topic of writing an Islamic will, please join me in welcoming Syed Maulana Muhammad Rizvi with a loud salawat ala Muhammad wa al Muhammad.
أعوذ بالله من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيد الأنبياء وخاتم المرسلين سيدنا ونبينا بالقاسم محمد وعلى أهل بيته الطيبين الطاهرين المعصومين واللعنة الدامة الباقية لأعدائهم من الآن إلى قيام يوم الدين. Amma ba'd, sisters and brothers in Iman, Assalamu alaikum. The topic on which we have this gathering is a very important issue for each one of us. We have previously organized seminars on this theme, but it is an issue which can not only be discussed once and then we forget about it. People go through different changes in their lives, and this is an issue which is very important for us. You already heard from the legal perspective the importance of having a will. From the Islamic point of view, let me talk about it by raising this question: why we are discussing about writing an Islamic will? If you go to India or Pakistan or Iran or Egypt or even in Tanzania, they really don't talk about it. And the reason why they don't talk about it, because the system there already caters to the Sharia perspective of the laws of succession. In India, although it's a secular country, but even before the independence, during the British time, they had something known as Muslim personal law, where Muslims, even if they take a case to the civilian court about marriage, divorce, or inheritance, the civil court will decide according to the Sharia laws. If a Shia couple goes to an Indian civil court on talaq or inheritance dispute, they will, even though the judge might be a Hindu judge, but they are familiar with the Ja'fari laws because they have to deal with that. And so in places like that, you don't necessarily have to think about these issues of miras. But here, it is different. Here, Sharia is not recognized in that way. So although initially when it comes to this issue, whether it is necessary or not, no, it's not wajib to write a will. It is recommended. But looking at the consequences, that if you don't have a will, what happens? And I'll just talk about one part of it, that if you don't have a will, and if there is a dispute, and if they end up going in the court, or the division is done in a way that the heirs end up getting more than their share, then there is a problem from the Sharia point of view. That mal for them will be ghasbi. And it has very far-reaching consequences. And so although it's not wajib, but by looking at the situation here in Canada, keeping in mind that the law of the land allows us to write a will, to dispose our estate the way we want, why don't we avail that, opportunity or the freedom that which has been given to us? We do not necessarily have to spell out there that this is an Islamic will. You just say, this is how I want my estate to be divided. It would be according to the Islamic laws, but you do not have to specify that this is according to Islam. Now, what happens as far as the Islamic perspective is concerned? I would like to move very quickly. I realize many questions are going to come up, so we'll give more time to the questions. When it comes to the estate of a person, how much control do we have after we pass away on our taraka, on our estate? There are three possibilities. Either you have the possibility of full control, or if you live in an extreme, communist system, you don't own anything, even in your lifetime, so let alone after you die. Or there is a possibility of a partial control through a will. Islam doesn't agree with the first one or the second one, it goes with the third option. You don't have control over your total estate, you have partial control provided you write down a will. And this is where the writing of a will becomes very important. Now, when we talk about this partial control, how do things work out? If you look at that slide, the entire estate can be divided into two, 1/3 and 2/3. When it comes to the 1/3, that's where you have absolute control, that how it's going to be divided. You can write it to anyone, family, outside family, in community, friends, Muslim, non-Muslim, this institution or that institution. You have absolute right to decide whatever you want to do. But when it comes to the 2/3, that's where the Sharia says your hands are tied. You don't have a right. The 2/3 have to be divided according to the shares that Allah subhanahu wa ta'ala has specified in Surah An-Nisa, the 4th chapter of the Quran. In Islamic laws, and this is an important point to keep in mind, whenever they use the word al-wasiyya, a will, and the issue of inheritance, mirath, these are two different discussions. If you look at the classification in Islamic laws, there is a section known as Kitab al-Wasiyya, the section dealing with writing a will. Then there is another book, not following that, in a different section, where it's called Kitab al-Irth or Kitab al-Miras, which deals with the issue of inheritance. Wasiyya only relates to the 1/3. It has nothing to do with the 2/3. Wasiyya means whatever, right you have been given in the 1/3 of your estate. 2/3, whether you make a will or not, has to be, distributed according to the laws of the Sharia. And we'll talk about this issue of 1/3, 2/3. This is a lot of flexibility which has been created by the Sharia system. Now, what is an estate? It's very simple. Whatever you own at the time of death becomes the taraka, the estate. And so the process would be, first, all the debts have to be paid out of it, whether it's legal or religious. And then you see whether the person, the deceased, has made any will about the 1/3. So then you dispose that 1/3 or up to 1/3. It doesn't have to be exact, 1/3. And then whatever remains has to be distributed among the heirs. One of the questions which came before the program was the issue of life insurance. What happens to life insurance? Is it to be considered part of the estate or not? From the way I talked to some of the brothers who are expert in this field, when it comes to the life insurance, it is not part of the estate of the deceased, because there is a beneficiary there. The deceased was just paying the premiums. The money is generated upon his death. It didn't exist when he was alive. He didn't own it in that way. And when it was generated, it had a name on it. There was a label on it. So it becomes the property of the beneficiary, and it doesn't become part of the estate from the Shari'i perspective. Our brother talked about this issue of joint account and the common ownership, especially for the real estate property. And this is where we see the tension between the Canadian laws and the Islamic laws. We saw that, in Canadian laws, upon death of one spouse, the money or the real estate property, whatever is in the common ownership form, will be automatically transferred to the surviving spouse. Does the Sharia accept that? No. According to the Sharia, according to the Islamic laws, the half, 50%, belonged to the surviving spouse from before. The other half becomes part of the estate. And so there is a complication in how we handle this. And we will come to this, especially, even in the book, The Writing of the Islamic Will, in page 8, I talked about the problem. In page 13, I've given 3 solutions. I'll mention also only 2 here in the slides. One is that, and doesn't apply to all majority of us. If whatever you have, especially the real estate property, if that is within the 1/3 of your total estate, then you can easily write in your will that, my share of the property, I'm half owner of it, other half is of my wife, for example. When I die, I want the other half also go to her, part of the right that I have in 1/3. If it is more than 1/3, then an easier way would be to sit down when you're writing the will with the other heirs who have the right in your estate to explain to them what you intend to do. If they give up their right, let's say your parents or your children, explain to them, in case of a husband, for example, I would like to leave the house to the wife. And if they say, okay, Baba, we don't have any help, or the father and the mother says, no, we have lived our life, we don't want, then you can write that down. According to Sharia, their consent, even once, is sufficient. And that's not revocable. So when you are dealing with children, especially, it has to be children who are mature enough to understand the implications of the consent that they are giving. Now, if this first and second solution doesn't work, there is a third one we have found. And we're going into Sharia laws to see some of the mechanism we can find to deal with this issue, and that is known as a hiba. Hiba means, for example, the husband gifts the house in his lifetime to the wife. I remember in one of the seminars when I mentioned this as a solution, this is before I wrote the 6th edition of the book. One of the brothers came and said, well, Maulana, you are saying I can give it to my wife in lifetime. What if she leaves me? What happens to me then? Then we looked at it and we said, okay, there is something known as hiba mashruta in fiqh, in our Sharia. Conditional gift. You're going to have a deed there, written according to the Sharia saying that I give to you this house with a condition, as long as you are my wife and, I die before you. Otherwise, it comes back to me. And so that is one way of how we would handle this situation from the Sharia perspective in order to bring the Canadian laws and the Shari laws, close to one another. Now, the normal, when we talk about the issue of, how 1/3 is used, the possibilities are, very vast. This is just a very simple, explanation of it, the issue of charity, giving to those relatives who do not have a share in your estate, giving to those relatives who have a share in the estate, but you think they are more needful, they are more needy and they should be getting more. You can always use this 1/3 option to give more to them. And of course, if you are dealing with the issue of qaza, prayers and fasting, or the hajj which has not been done, this is where how you can use the 1/3 option. Quickly moving on to the classes of heirs. In the Sharia, we divide the heirs into 3 classes. Number 1, the first class is of parents and children and their descendants. The second class of the heirs is grandparents and siblings and their children. And the third class of the heirs is basically the uncles and aunts from both sides and their children. What is the implications of dividing them into 1, 2, and 3? As long as there is, of course, I forgot this one. You can have 1, 2, and 3, but the ever present is the spouse. Your husband or wife is always there. Now, the spouse doesn't lose his or her share in any situation. But when it comes to 1 and 2 and 3, the reason why we classify them is because of the implications. For example, as long as one person is alive from class 1 of the heirs, the second and the third class do not come into picture at all. So if you're a person who dies and has a parent or a child or a grandchild, then the grandparents or siblings or their children don't come into picture at all. And even their aunts and uncles and their nephews and nieces, they don't come into picture at all. Even if one person from that first class is alive. And the reason I have written children and then grandchildren and put the grandchildren in a gray area, there is also an issue of one generation barring the other generation. So you could have a deceased who has a parent and children and grandchildren. Well, if the children are there, the grandchildren don't come into picture at all. This would be more relevant when you look at let's say, a deceased who leaves 3 children. One of them died in his lifetime and has children from that child. So he has grandchildren who are orphaned. But because he has surviving children alive, the orphan grandchildren will not get the share because the generation before them is preventing them from that. And this is one example where you can always use, if you want, the 1/3 option of giving to those grandchildren who will not get the share because their father or the mother was not alive at the time of the grandparent. This is just the same issue, that if there is no one from the first class, if there are people, even one individual from the second class of the heirs, then the third do not come into picture at all. Let me now very quickly go through the shares that the Sharia has specified for individuals. I don't want to go into the numbers, we'll just go through it very quickly. The easy way was just to look at ourselves there and our heirs. So your father, what will he get if you have a child or you don't have a child? It makes a difference. Your mother's share, if you have a child or a brother, it becomes more or less depending on that. In case of the wife, the husband gets, depending on whether they have a child or not. Again, the shares will change. Similarly for the case of the wife. And when it comes to the children, there is no specified share for them. So after the estate is divided by giving, disposing 1/3, giving to the spouse and the parent or parents if they're alive, whatever remains goes to the children. And the proportion would be between the male and the female, that the male child will get double of the share of the female child. And this brings me to this very controversial issue. That, why does a daughter get just half of the share of this son? Number one, it's not a sexist issue. It's not an issue of, male against female. It is based on the concept of financial responsibility in an Islamic, system of family life. Those who have been given greater financial burden will get greater share in inheritance. So when the wealth is distributed from one generation to another, it is not just the gender issue, it is the issue of the level of responsibility. Because remember, in the words of Amir al-Mu'mineen, he says, a haqq, right, does not exist in a vacuum. Rights are always tied to responsibilities. So there's nothing like mine rights or your rights unless there is a duty and responsibility, tied to it. You look at this scenario, and of course, I'm not saying everyone is like that. You have this diagram, which is there even in the book. You have a son and a daughter. A son gets married, he has a wife and 4 children. This is just the minimum we could show there. And basically he is responsible for his wife and children. He has to provide for them. On the other hand, the daughter, she becomes the responsibility of the son-in-law. And so because the responsibility and burden on a financial level is more on the son than the daughter, when it comes to the division of wealth from one generation to another, this is what Islam would look at it. And this is how the division would be done. But then, the question comes up that, not all daughters will have a husband who can comfortably take care of them. And you as a parent are more concerned about your daughter who's married and going through financial difficulties and challenges compared to your son who is okay on his own. Well, this is where the issue of 1/3 comes in. Don't say, Islam is sexist and this and that. Islam has given you this option of using up to 1/3 of your estate to deal with these situations which you might not consider to be the normal situation. And so, for example, if you look at, and this is where I'm saying, the 1/3 option that Sharia has given makes things very flexible as far as Islamic laws are concerned. Look at the scenario. If a person dies and has a son and a daughter as his only heirs, and he doesn't, use the 1/3 option, what happens? The son gets 2/3, and the daughter gets 1/3 of the 100%. But then that deceased had a right to move the numbers around, to give more to the daughter if he felt that she needs more. And this is what it can be done. So you look at 2/3, and you divided it, 44.44 for the son, 22.22 for the daughter, and then you take the 1/3, where you have absolute right, and you shift the numbers around, and you give only 5.56 of that to the son, and 27.78 to the daughter, and what is the end result? You get 50-50. So you can do that in the Sharia by using that option of 1/3. Now, very quick, let me just go through the book that you have in your hand there. Basically, what we have done there after talking about these issues, we have about 36 most common cases. We've given charts out of 100% as well as with the option of 1/3. And what you need to do is just look at the relevant situation of your own family and your possible heirs, and then go to that chart, and that is where you will be able to know how your estate would be divided according to the Sharia. And of course, if there are issues which has not been covered there, you can always, call me or email me, and we'll give you the answer. There's no fees, nothing. It's all free. Don't worry about it. This is just an example of the way the charts we have been given there. This is one scenario. 1A is wife, son, and daughter. And 1B is basically wife, son, and daughter with the option of 1/3. We have at the end of the book a sample of Islamic will. This is not something you can just photocopy and fill in the blank area. No, you have to come up with your own version. This is just a sample and a guide. You will see that in some areas we have box with a yellow background. That is just guidelines how you deal with that paragraph. Especially, for example, we have a note there about keeping an inventory of your documents as well as your assets as well as whatever you have, so that it becomes easier for the family later on to find everything in one place. They don't have to go through the documents and papers looking for it. Somebody forwarded me last week a very good 20-page document known as the Family Inventory, prepared by Royal Bank of Canada. It's not a promotion for them. This is a promotion of the book, actually. And it can be downloaded free, and you can use that to put in all information in one place. Finally, let me end with advice from Sheikh Mufid, where he talks about how to use the 1/3. He says divided that into 4 parts. 1/4 for qaza, namaz, roza, and kafara. 1/4 for the relatives who do not inherit, maybe an uncle and aunt that you love more than others, and they have taken care of you, and they are not part of the heirs of your estate. Then you can always give from 1/3. And of course, this is Sheikh Mufid's recommendation, for the deserving poor Sadat, and the rest for the poor Shia in general. And you can always, include the Jamaat, although they have not asked me about it, part of, what you want to give in the 1/3 to deal with the issue of the debt that we have in the community. Wassalamu alaikum wa rahmatullah.
Thank you, Maulana Rizvi. Could we please have a loud salawat ala Muhammad wa ala Muhammad? So we will now be proceeding to the question and answer portion of the program. Just for all of you to be aware, we do have a hard stop for Salat, so we will be ending the session at 9:10 with some closing remarks, so please be conscious of that. Just some guidelines when you're preparing your questions. Again, if you have some very, very specific questions, we would advise you to speak with Samil or Syed Rizvi privately so that they can give you a more customized answer to your question. That said, we also advise and request that everybody please keep their questions short and to the point so that we can fit in as many questions as possible. Finally, as I mentioned, there are pieces of paper and pens circulating. So if you do not wish to say your question verbally, just put it on the piece of paper, pass it along to one of the volunteers. You can pass it along to Abbas or Azim over there, and they will be able to pass it up to the front. There is a mic on the sister's side, just by the partition, and there is also a mic floating around. Azim's holding it over there. And so if you do have a question, just put your hand up and he will bring the mic to you. So we will begin with Brother Shabir.
Thank you to both speakers. I have a couple of questions, but I'll start with two to give others time. The first question is to Brother Samil. You indicated that there is a 6-month waiting period for distributing assets after your death if you have a spouse. Two-part question. If there's no spouse, but there are other family members, is there a limit on distributing assets? And the second part is, can any assets be distributed within those 6 months, but not all, or no assets can be distributed?
Thank you very much for the question. If you don't have a spouse, then my understanding of the law is that you don't have to worry about the 6-month waiting period. Let me clarify that the purpose of the 6-month waiting period is because the spouse has a 6-month limitation to file a claim in the court if they choose to elect under the family legislation as opposed to inheriting under the will. So there's a time limit there for the spouse to take some action, and so that's why the 6-month period is there. The second part of that question, the proper answer would be that all assets should be frozen, as it were, because when the spouse makes that election under the family legislation, it still remains to be determined what the actual equalization or the value coming to her would be. That being said, like anything, if you can get consent, if the spouse consents to a partial disbursement of the estate, up to, let's say, half of the estate, because the spouse might know, well, I'm only entitled to the other half anyways, there are ways that you could get that consent in place to be able to do a partial disbursement.
Second question is to Maulana Rizvi. You gave the example of joint accounts, and that at the time of death, the Islamic Sharia is different from Canadian law in that the spouse does not automatically get the other half, it goes to the estate. You also gave the example of life insurance that is an exception. If there's a named beneficiary, the money goes to the spouse, for example, it would not be within the estate. Another common example would be an RRSP with a named beneficiary. Would it be considered like a joint bank account or like a life insurance policy with a named beneficiary?
It's a good observation. I'd made a note here. Now, if the RRSP has name of a beneficiary on it, then it will be considered the property of the beneficiary. It will not be Shari'i-wise part of the inheritance.
And just on that note, there is a question in writing here that relates to that. The question is, if you have an RRSP, after you die, how much will the beneficiary pay on that RRSP? And the question is really more of a financial question, but the answer would be, it depends on your marginal tax rate. So if the beneficiary is going to be cashing out that RRSP, whatever that person's marginal tax rate at that time is, if the person's retired, likely their marginal tax rate will be a lot less than somebody who's in the middle of full-time work. So it depends on your tax rate.
Okay, before we take the next paper question, I believe Brother Mohsen.
Brother Samil, can you just confirm that if it is a handwritten will, then you don't need to have it, witness, and you can write your handwritten will, and that will be sufficient. And then I have a second question. I just slightly lost you on the RRSP. When you have named children as a beneficiary in the RRSP, for tax reasons, do they immediately get the money, or does it, go in the tax return and the tax have to be paid before the children get it? Or whether it gets paid immediately to the children by deducting the tax. What basically I'm trying to get that if you have named the beneficiary, then you don't have to file the tax return. It goes immediately to the children, and the tax is deducted.
Okay, I understand your question. To deal with the first part, the will in writing, there's a special name given to this. It's called a holographic will. I didn't mention it because it's not very common. Not a lot of people do it, but the law does technically allow for what's called a holographic will or a self-written will. And in that case, if somebody were to do a last-minute handwritten will on their deathbed, for example, as a type of scenario that you might envision something like this happening, the law would uphold the will, and the will would not need to be witnessed. However, the reason why these holographic wills aren't promoted a lot is because the will could still be challenged afterwards for potential lack of capacity, meaning that a beneficiary or a potential beneficiary could raise the claim to say, well, perhaps this person who wrote their last-minute holographic will, or maybe even if it's not last minute, but wrote this holographic will, maybe they didn't have the mental capacity to be able to devise their estate in such a way. You open it up to challenges when you do that, which is why it's a safer course to do a will prepared with witnesses and with the formal requirements, so that that issue of capacity can be dealt with, or certainly it doesn't become an issue, right? Because if you have witnesses there, the witnesses have to ascertain, and the lawyer who's preparing the will would ascertain that you actually have the capacity to make those intentions clear. The second part of your question with respect to the RRSP, it doesn't form part of your estate. It would go directly to the beneficiary, and then it's up to the beneficiary who might want to continue to reinvest the RRSPs or cash it out at that time. I think that's a question maybe an accountant would be better situated to address that, how can they then defer the tax later on? And perhaps this, a young man who's receiving the beneficiary of an RSP in his 20s, maybe he doesn't want to cash it out at that point. Can I defer it later on so that I don't have to pay the tax, burden at this point in time? I'm sure there are ways, but to be fair, I don't know for sure. I think it's better to check that with a financial advisor in terms of how you can reinvest that RSP if you are on the receiving end of it. I do have one question here in writing. It's an easy one to answer. The question is, does a will expire? For example, after 3 years, 5 years, does it expire? Simple answer is no. The will doesn't expire. It's not like your health card. You have to go and change it every 5 years with a new photo. It's good. It's like the old red and white health card. It's good as long as you don't do anything to change that. The will continue to that effect. Unless, of course, you write a new will and you revoke the previous will or something like that. Otherwise, the will is good and valid and it will continue unless otherwise, you've done something to change that.
So we'll take a few more questions from the written. There is a bit of a pile, so we'll just take a few more from the front.
There's a question here which says that if you have a child who is a gambler and does other non-Islamic or has other non-Islamic habits, can you delete him from your will? It's not that easy. You cannot use that as a reason to bar your child from his share. You can always use 1/3 and give it to others in the family. So his share or her share will become less. Or you can give, if it's possible, everything in your lifetime to others. So nothing is left for the gambler child. But you cannot, stop the child from inheriting. The only reason would be if a child becomes kafir or the child is, the judgment is passed that he is the one who killed the parent, then he will not get anything from the estate. But there's nothing like becoming a sinful person doesn't prevent the person from getting their share in the inheritance.
We'll take one more written question and then go back to the audience.
If your parent did not write an Islamic will and the executor of the will does his job, but you get more than your share, would it be ghasbi? Yes, you will have to sit down with the other heirs in the family and come to an understanding and compromise on this issue. Because you cannot get something by depriving other heirs of their share of the inheritance.
Next question from the audience.
Brother Samil, how can one avoid probate fees, if at all possible, or minimize them?
I don't think you'd be able to avoid probate fees unless, of course, the balance of your assets are less than $1,000. Then it's clear the law says if you have less than $1,000, you don't have to pay any probate fees or estate tax. So in theory, if you wanted to achieve that goal or something close to that, you have to work with a good estate planner while you're alive to say, look, this is what the inventory of my assets are and my debts are, and make your gifts while you're living. To say, look, these are the properties that I have. I could go at any time, but you're making your transfers while you're living, putting the property into the intended beneficiary's name, so that by the end, the day that you actually do die, what's left in your name, what's left in your estate becomes very little. That's the way you would have to do it. And working with a lawyer who is also not just a wills practitioner, but a lawyer who does the estate side of things. It's very important if you're going to seek legal advice, to work with a lawyer who knows both ends of it. Not just the wills before, but how to deal with the estate administration, because they'll know sort of the tricks and trades and the nuances of how things would have to be paid and how to plan against that when you're doing your will. So that's what I would do if you're trying to achieve that goal of minimizing the tax liability.
So we'll take the next question from the front. I believe Syed Rizvi has an answer.
There's a question here: what happens if a man has no biological children and his will cannot be found after his death? Does his wife inherit automatically? Well, if there are no children there, still you have to find whether they are heirs from the other second or the third class of relatives. So in case of the husband not having a child, the wife will get 25% of the estate, and the rest will go to the other heirs from the second or the third class of the relatives.
We'll take the next one from the audience.
This question is to Brother Samir. We understand Maulana said here about 1/3 that we can do on our own wish. What about from Canadian law? Can we do preferences in writing a will? Like we favor one side of the family and the other is denied. Like
I understand
there
your
was
question.
a question here about doing something haram and things like that.
Sure.
So does
I understand
Canadian
your
law
question.
allows preferences?
Sure. Let me address that. So Canadian law, there's no problem in preferring one beneficiary over the other. The law does not say that you must leave things in a certain way to certain people. For example, you must leave it to your children or parents, etc. I'm going to qualify that. Although the law doesn't prevent you from preferring one beneficiary over the other in whatever share that you want, you have to be mindful that there are these two protections in the legislation: dependents, dependent children or dependent spouses, or even a dependent parent. For example, somebody who's a dependent on you, there's that protection that allows the dependent to bring a claim against the estate if that dependent is not adequately provided for. So that's one thing you need to worry about. The second one is the spouse. Like I said, the spouse has a right to elect either an equalization, a 50-50 type of division under family legislation, or under the will. So you might legitimately, validly say, I'm going to prefer all these intended beneficiaries, and maybe, for example, your minor children aren't one of those beneficiaries. In theory, there's nothing wrong with that. You're allowed to do that, but you are exposing yourself to some liability, because that minor child will come after the estate and say, you haven't provided for me, I'm entitled to that provision. So that's how I would qualify that. Otherwise, there's no problem in preferring one beneficiary over the other. You could, for example, leave all of your wealth to a brother and nothing to the other brother. I mean, the one brother might be upset about it. He might try to find ways to attack your will, but as long as the will is done properly, it's okay. Yes, yes. Well, raising it in a court of law is different than being successful in the court of law. So I should just highlight that nuance. Somebody who's a disgruntled potential beneficiary who might have inherited less than that person thought they were going to get can raise all sorts of problems in the court of law and drag things through the legal process. At the end of the day, will they be successful? Maybe, maybe not. That depends on the facts. But it doesn't stop them from raising it through the courts. I'd just like to address a couple of questions in writing here. There's some simple ones that I can address sort of in omnibus. Is a will valid if it is written in any language, Gujarati, French, anything like that? The will would be valid. The law in Canada only provides that the will has those certain formal requirements, that it's witnessed, it's dated, etc. It doesn't require that the will be done in English. It doesn't even say that it must be done in one of the official languages. It's silent on that issue. If it's silent on that issue, then there's no problem, in the sense that if you write the will in Gujarati, for example, it can be valid as long as the other requirements are complied with. What I would suggest, however, is if the will is going to be situated here, keep a translation of it available, keep a certified translation with the will so that it's readily readable by the potential, trustees and so on. A couple other small questions that are here. If property is in joint name, is it like a joint account? Yes. If you hold property as joint tenants, for example, your primary residence, it's like a joint account. If you pass away, the other person who's on title with you, either on that joint bank account or that joint primary residence, will automatically take over the full, whatever it is, the full balance, the full house. So it's just like a joint account.
I have a question on the sister side.
Assalamu alaikum. Actually, first of all, I want to show my appreciation for Maulana Rizvi's redone booklet, and also for Brother Samil's presentation here today. What I want to do next is just add to the discussion that's happening over here, where somebody asked about how can one minimize the probate fees. And one thing that has not been discussed right now is that if for the monies that are over and above the day-to-day needs of the very elderly person, for example, the monies can actually be invested in a segregated fund contract, and especially because when you have more than one child and you want to distribute those monies, then it's better to have that money in a segregated funds contract and have the named beneficiaries. And there are a few companies that will issue that kind of a contract up to age 90. So that is available. Thank you.
Thank you, sister. We have a question here at the front.
This question is for Maulana, but before I do that, just to clarify the RSP issue. If you have an RSP and the spousal is the beneficiary, then it goes over to the spouse tax-free. If it's not a spouse, then the estate has to declare it as income. There's no rollover of that RSP, so it just becomes cash that goes to the beneficiaries. My question to Maulana is, if you're an executor of a will and that will is not in compliance with Sharia, what is your responsibility as an executor? Do you fulfill what the will says or what the Islamic obligation is?
To avoid that situation, you have to first, when you agreed that you are going to take on this responsibility, to see whether it is according to Sharia or not. But at least you have a sense that, okay, the potential heirs have come to an understanding on how things are going to be done. Otherwise, you become part of the process of depriving one or the other from their rightful share. And that becomes a problem.
Responsibility, and then something changed and the will wasn't updated. And then that put the will offside.
I think you'll have to somehow put all parties together, explain to them the reality as far as the Islamic perspective is concerned, and bring them to a compromise on that.
Before we move on to the next question, I've been informed that we have these feedback slips. You'll see them going around. It asks you to rate the program on a scale of 1 to 5, and also to suggest topics that you would like to see discussed in a similar format. So before you leave, I highly request everybody to please fill out this little slip. You can get them at the tables, and I know a lot of them are being passed around, so please do so before you leave. Thank you. We have a few questions from the front that I think we'll take.
One question here is, according to Canadian law, what happens if both parents, spouses, died together? Perhaps, in a car accident or a plane crash, died simultaneously. What would happen in a case like that is the beneficiaries of the estate would be the children in that case, because it depends on whether or not they die with a will or without a will, first of all. But assuming that they didn't have a will in that situation, then the law would say, the spouse gets the first share, but the spouse has passed away at the same time. So then you would look at the children who would benefit, who would gain everything else. In a case where you had joint property between the spouses, this joint survivorship, they both owned a matrimonial home or a primary residence, normally one would die and the other spouse would receive the balance of it. If they died together, then what the law says is that joint tenancy, that joint property, is automatically converted to a tenants in common, which means that the joint part of it gets severed and they're treated as if it was just 50-50, tenants in common, so that each of them has their own 50% of that house that was joint and would have had those benefits for it. It'll be considered as a 50-50 ownership that'll each flow to each of their estates. Chances are, if their estate is just the children, well, the kids are going to benefit anyways, but if they had a will that specifically left their estates to different intended beneficiaries, well, then that 50% of that house would go to, according to one will, and the other 50% would go based on the other will. So that's what would happen in that case. Is it advisable to have any of your children as executors or co-executors? It's advisable, it's not advisable, it really depends on you. It's not something that we would discourage people from doing. At the end of the day, you want to make sure that it's somebody who is trustworthy, that you have faith will take care of the administration of your estate, that will make sure that things are devised and bequeathed and given properly to the intended beneficiaries, that they'll make sure that the probate fees are paid, that the final tax return is done, that they're not just going to stick their head in the sand and say, oh, I don't know what to do. And you want to be able to, it's somebody trustworthy, which is why it doesn't have to be a child. It could be a close friend, it could be another relative, it could be a lawyer. It just has to be somebody that you trust will be able to take care of what needs to be done if that situation should arise. A question arising in some cases when a person is declared unfit, mentally incapable, there's a government department called the Office of the Public Guardian and Trustee. They can take over the estate of a person who's not capable. So the question is, would doing a will or a power of attorney or something like this help prevent that situation? The answer is yes, of course. That's what it's for. If you had a power of attorney for somebody who later became unfit, for example, a power of attorney for personal care or a power of attorney for property, I think that's the more important one here. Somebody later becomes unfit to manage their estate, rather than letting the public government department called the Office of the Public Guardian take over. You already have a power of attorney that a relative or whoever is trustworthy who's been named in that to be able to manage the affairs. That's one exact reason why you should set up powers of attorney for property and so on, to prevent against that type of a situation happening. Why let the government, not that they'll take anything, but it's just that it's extra bureaucracy, it's extra levels of paperwork you need to go through to be able to just live your normal life. Whereas if it's a power of attorney, you can manage with those things easier to make sure that the person who it's for gets the the treatment, the financial need, etc. that they need.
So we will take one question from the audience, and then I believe Maulana has some questions at the front that he's able to answer.
So my question is for Syed Maulana Rizvi. A lot of what we've been talking about tonight for wills is the allocation of our property and our material goods. However, if we look at the lives of the Ahlul Bayt, a lot of them have made requests for people to behave in a specific way, or to act in a specific manner, or carry out a funeral a certain way. So if we have requests like these, would these also go on the will, or is this a separate document, or is there a different procedure, or how would that work?
The will that you see in many ahadiths, for example, in Nahj Balagha, there is a will which was made by Amir al-Mu'mineen between Zarbat and Shahadat. Those are not the will the way we talk about it now. Those are more religious advice given by the Imam for the family as well as the community at large. That's the will that we are talking about here, is more to do with our estate. How is it to be, disposed and handled after we pass away? There are actually similar wills by the Imams dealing with these issues. Amir al-Mu'mineen had many gardens which he planted with his own hand, palm trees in huge numbers, which he even made it as endowment for charity also. And so there are certain documents where he only talks about that and not about advice giving to the normal people. So the will that we are talking about, the wasiyyat, this is to do with the issue of inheritance and the estate. So there's a difference in how, the wills are drafted. There's a completely different area of discussion.
So we'll take a few more of the written questions.
We have a question here. How do I divide my set, dagina, from my parents, from my in-laws, and from my husband, both from the time of marriage till now? Number of years, I wouldn't say. Well, whatever you got from your parents, from your in-laws, from your husband, that's yours. And you can do whatever you want in your lifetime. And if you have not distributed it normally, from what I hear, the mothers, normally they divide it among their daughters or daughters-in-laws in their own lifetime. And if that's done, that's okay. But if they leave it just like that when they pass away, then that has to be distributed according to the Sharia laws. Another question is that if the husband and wife have joint account, but all the money is from the husband's earnings, does she still get 50% after his death? Looks like it's coming from the man's side, huh? Well, we'll look at the documents. Whatever the document says, it's joint account, it's 50-50. Unless it was specified in the will that that money is not entirely of my wife, this much is mine, then that's a different issue. Otherwise, the way things are on paper, we just go with it as 50-50. What happens to GIC if we name the beneficiary? Does it go to the estate? No. Whatever you have in the name of a beneficiary, it goes to them, it becomes their property, they have to deal with it.
Our next question is from the audience, so we'll just take it from Brother Riaz.
This question is for Maulana, just a follow-up question from something that was previously asked about the son, and if you didn't want to give part of the inheritance, and the exception would be if they're kafir or no longer Muslim. Was that correct? Did I hear it correctly? And does that apply to all different? So if it's a parent or a sibling or a spouse, or is it just for the child that they're non-Muslim, then they don't qualify for the inheritance?
According to the laws, there are certain issues where a person is barred from inheriting from a Muslim, and one is kufr. So it doesn't matter with the child or the parent or a relative who might be a potential heir. If he or she becomes a kafir, then they will not inherit from a Muslim.
So we have a few more questions from the audience. First, just the gentleman in the front, and then a few at the back. But before we do so, we are cutting it close to time. So for those questions that are, outstanding, at the end of the question and answer session, please note them down on a piece of paper. We will ask Maulana Rizvi and Samil to prepare an FAQ document or an outstanding questions document that will be emailed to the email addresses provided at the registration desks. So if you'd like access to those questions and the answers, please make sure to provide your email addresses to the volunteers at the tables on my left and right. And then again, if you have any outstanding questions that haven't been addressed, please make sure to note them down, hand them either to the front or to either some of the volunteers, and we'll make sure that they get answered in some way or form after the program. Thank you.
Assalamu alaikum. Just a question for Maulana. Maulana, you had said that for life insurance there is no, all of it goes to the beneficiary because there's no real money there. And same thing with Kums, right? There's no Kums on the life insurance benefits. However, for RSPs, there's Kums, the money is there. How come it only goes to the beneficiary and not to the dependents?
When it comes to the life insurance, we said that it becomes property of the beneficiary. We didn't say it's homes free. We didn't say that. That person will include that in his calculation of homes of that year. If he ends up using it, there's no homes. But if it's still with him or her, when the homes date comes, there is homes in it. There is no homes in inheritance. So even if a person inherits $10 million, there is no homes on inheritance.
We'll take another question from the audience.
Yeah, I can. Maulana, I just want a clarification. Did you say that the proceeds of insurance are dealt same way as, like if in your RRSP, if you have named a beneficiary, they don't form part of that? But then what is the difference between an RRSP beneficiary and your house you putting as a beneficiary? Because RRSP is cash. Insurance is different because insurance doesn't belong to you. It will only take place after your death, and you may not even see it. If it is a term insurance up to 65, if you reach 65, nobody will get it. But RRSP is cash money, like any other cash. Just my thinking, so I wanted to clarification.
You see, in order to avoid tax, you put it in that account. You use that mechanism, and if it was directed to you, that's a different thing. But if you put somebody else as the beneficiary, and at the end they get it, they are the one who have to deal with it. It's not part of the, when it comes to the issue of house ownership, it is known as common. And common means basically you're looking at half and half. It's the Canadian law which says when one, spouse dies, the other becomes automatically the owner of it. You didn't really say that, okay, this is mine, and when I died, so-and-so becomes the beneficiary, just like RRSP, for example, or the life insurance.
We have a question at the back.
This question is about joint account. After you get the joint account, how do they determine the probate tax? Because it's a house. Do you have to sell the house?
If it's a matrimonial home or a primary residence and the property is flowing to the surviving partner, then it's outside of the estate. It doesn't have to be probated, right? It automatically flows to the surviving spouse. However, there could be potential capital gains issues involved. If it's a primary residence, normally that's an exemption recognized, right, by the CRA in the Income Tax Act, that we don't have to pay this capital gains if it's your primary residence. So chances are if you're a spouse receiving the other 50% of your joint property, and later on if you die, you don't have to worry so much. But if it's a joint property, let's say between a father and a son, right? The joint property will go to the son, but the son at some point is going to have to be on the hook for capital gains in terms of the Income Tax Act, even though it's going to flow outside of the estate. It won't be part of the estate, so you don't have to worry about estate tax. The son, whoever receives the other half, will have to worry about capital gains, though.
So we have a few more minutes, so we'll try and address as many of the written questions that we have at the front. Again, if you have any outstanding questions, please note them down. We'll collect them and then distribute them to the mailing lists as per what you've registered with at the desks. So we'll try and get through as many of these as possible just before Namaz time. We have a few more minutes.
I have one really good question here. Should a will be sealed in an envelope and opened, after death and so on? This is really interesting. The law doesn't require one way or the other, but practically between you and me, unless there's something, really interesting you're trying to do with your will, I would just be clear with the beneficiaries while you're alive. Be clear. look, children, this is what my intention is. I'm going to be leaving my property in such and such a way. And maybe you've, received other gifts from us at a different stage in life, and, that's why I'm going to be doing it this way. Be very clear, if you can, if there's reasons not to, with your beneficiaries. Look, this is what I'm going to give you. It's in my will. You don't have to see it, but if you really wanted to see it, I guess, it's here. But if you do that while you're alive, you'll minimize the disruption afterwards, because there's going to be less likelihood of beneficiaries fighting afterwards over your estate, trying to drag things to the court to say, well, really, I should have got more, and this, maybe the will wasn't done properly. Be clear as much as you can with your beneficiaries while you're alive. So it doesn't need to be sealed and, under lock and key. It can be, right? But at the very least, tell your children, your survivors, where the will is going to be. Tell them, look, this is where I keep my coffin in the house, and my will is with my coffin, so you can get the two important things that I need on that moment's notice. No use keeping it locked up in a safety deposit box, for example, that you can't access for a couple of weeks, while you're dealing with the fallout. Keep it somewhere that your beneficiaries know where it is, where your executor, your estate trustee has been told that, look, I've named you as my estate trustee, right? So you know that you have this obligation. This is where I've kept my will, so you know where to look for it. Be clear and help those things go smoothly with that transition.
Sir Samil, we have one more question from the audience.
What does the law and the Sharia say if my estate is a minus? If I leave a debt of $1 million, for example, does the share go equivalent the way it goes when you leave $1 million?
I'll comment on the legal part of it, and I'll let Maulana comment on the moral implications of that situation arising. I don't know why it would arise, but practically, it's like what happens if you can't pay your bills while you're alive. You go bankrupt. An estate would have to claim bankruptcy, and all the fallout with that. All the creditors could be fighting and disputing the bankruptcy to say, no, we think something fishy was going on here. Maybe the person made some fraudulent conveyances to purposely put themselves in a negative financial situation. We're going to resist the bankruptcy. But practically, that's what has to happen. The estate would have to claim bankruptcy and be discharged from bankruptcy with all the creditors, signing off and all that. It's just like what would happen if you were in a negative situation while you're alive.
From the Sharia point of view, if you see, we talked about 3 stages of dividing the estate. One is paying the debts, and then disposing 1/3, and then division of the 2/3. So if the debts covers everything, nothing is left for 1/3, 2/3, then there is nothing left at the end.
So we have one question from the sister side.
Comment here that Samil just said is a personal segue into what I was going to comment about, which is as a financial advisor within this community for many years, I come across business owners all the time who do not have buy-sell agreements, and they do not have specialized wills that would actually take care of the problems that are bound, that you're well aware will happen if the will does not provide for their business assets. Another time?
So we have time for one last question before Salat. So if there's one up at the front that we can answer relatively quickly, and then we will conclude the program.
I have one question here. Is there a legal requirement that an estate be probated? You need to have your estate probated to get this court seal to be able to dispose of property. So if you're sitting on this, condo out in Kitchener or something like that, how are you practically going to sell that property? Well, you need to have the court document that allows you to be able to do that. And you need to have a clearance letter from the Canada Revenue Agency after you file this final tax return. So in some situations, certainly, you're going to be stuck with this property that you can't dispose of because you haven't done the proper steps in probating. Personal items and such like that, they tend to have nominal value anyways. In terms of listing them on your inventory of your assets, well, they're not worth anything. They're personal effects, they're trinkets. It's 20-year-old furniture. What's that worth? Chances are you can be able to move that around without much risk, I think, because they tend to have nominal values. Oftentimes with bank balances, banks will have their own documents in-house that you would have to sign off on to show, look, here's the will, this says that such and such is the trustee, and the banks will let you move some money around. If it's a lot of money, they might say, well, you better go and get it probated so we know that, the proper fees and so on have been paid. But if we're talking about modest bank balances, not $1 million, but modest bank balances, the banks will usually allow you to access those funds as long as you've signed their in-house documents.
Super. So as I said again, just a reminder, the questions that are remaining at the front, and if you have any additional ones, they will be answered via a FAQ document that will be sent out to the email addresses provided at the tables to my left and right. And so with that, please join me in thanking our speakers, Syed Maulana Rizvi and Brother Samil Chagpar, with a loud salawat ala Muhammad wa ala Muhammad. So just before we go for Salat, two very quick announcements. First of all, a reminder and a request to please fill out the feedback slips, just asking how you felt the program went today, and then also requesting feedback on what topics you would like to see discussed at future programs. So the wills, and we've had a previous event on COMS. These have been held by popular demand, so we're continuously looking for ideas. So if you do have any suggestions, please provide them to the front. And finally, an announcement from the Academy for Learning Islam, ALI. ALI will be offering a course called Quranic Arabic for Beginners. It will cover lessons from the textbooks, access to Quranic Arabic, and Quranic language made easy. The course will take place over 6 weeks on Saturday, starting June 16th, that's tomorrow, through to July 21st, just before Ramadan, from 12 noon to 1 p.m. Here at JCC in room B045. There is no fee associated with this course, but regular attendance is essential. So if you are interested, again, Quranic Arabic for Beginners at 12 noon, starting tomorrow for 6 weeks, every Saturday. It is open to students ages 15 and over. It will be held here at the JCC in room B045. And if you have any questions, please email academyofislam@gmail.com. And with that, thank you so much for attending, and we look forward to your feedback. Wassalamu alaikum wa rahmatullahi wa barakatuh. Adhan will begin momentarily. Thank you.